Well, good morning, everyone. Good morning and welcome to Law Day at Montana State University. My name is Brock Tessman. I have the pleasure and honor of serving as the 13th president of Montana State University, and I'm so delighted to have you all here with us this morning, joining our faculty, our staff, our students on this beautiful campus. I'm excited to have community members with us, members of the legal community, and I think I'm most excited about all of the middle school and high school students we have joining us this morning. Welcome to your land-grant university. Today, we have an opportunity to see Montana Supreme Court in action, and it's a unique opportunity, and I'm so glad to personally be able to experience it for my first time as MSU president. As you can imagine, putting an event like this together requires a lot of work, and I'd like to acknowledge many of the groups who've been involved. Thanks to Montana State University's Department of Political Science, our university's pre-law club, the State Bar of Montana, and of course the 18th Judicial District Court. Thanks also to MSU's Office of Student Engagement. Chris, I see you there. Thank you very much to you and your team, and our conference and event services team for all of their efforts today. And of course, the most exciting thing about today, we are here to peek behind the curtain of our state's highest court. And this glimpse wouldn't be possible at all without the Montana Supreme Court justices and all of the staff who've traveled here to Bozeman. Let's give them a round of applause. Our entire community looks forward to this event every year, and we're so grateful for the opportunity to observe our state's legal system in action. I'd like to reflect for just a brief moment on the specifics of the opportunity we have before us. Law Day is part of a national movement. It's observed across the country every year on or around May 1st, and it provides a meaningful opportunity both to celebrate the rule of law and to understand it better. It helps us understand how the law and legal process protects our liberties. It enables us to see how this process contributes to the freedoms that all of us as Americans share. And this sort of opportunity invites us to do something that we don't often make time for in our daily lives, to stop, pause, and consider the important system that impacts all of us. Taking a moment to reflect on the legal system reminds us that our liberties are indeed precious and that they are sustained through shared understanding, active participation, and a deep respect for these principles. Through your presence here today, the time you've invested in joining us, you are engaging in a very important process in helping to ensure that the rule of law continues to serve us all. Thank you. And now, it's my pleasure to introduce all of you to Elaine Gagliardi, who in March 2023 was named the Dean of the Alexander Blewett III School of Law at the University of Montana. Dean Gagliardi joined the law school in 1995 as a faculty member and was appointed to serve as interim dean in 2022. Prior to joining the faculty at UM, she worked with law firms in Missoula, Connecticut, and Washington. She also served as a chair of the State Bar of Montana's Business, Estates, Trust, Tax, and Real Estate section, and she is one of a few elected to both the American College of Trust and Estate Council and the American College of Tax Council. Dean Gagliardi has a bachelor's degree in economics from Yale University, a law degree from the University of Montana, and an LLM in taxation from New York University. After graduating from law school, she served as a law clerk for James R. Browning, Chief Judge of the Ninth Circuit Court of Appeals, and William J. Jamison, Senior Judge of the U.S. District Court of Montana. Dean Gagliardi, welcome to Law Day at Montana State University.
Thank you for that introduction, President Tessman. Good morning. My name, of course, is Elaine Gagliardi, and it's really a privilege to serve as Dean of the Alexander Blewett III School of Law. So Xander Blewett is a graduate of MSU, a very proud graduate of MSU, and we are so thankful every year to welcome so many graduates of MSU to our law class because we are Montana's law school. I want to thank everybody for being present here today to observe our legal system at work. It's a pleasure to be able to visit with so many alumni in the audience and to see so many students and prospective students. And as you all in the audience decide what you are going to do, I will tell you that being a lawyer is a true honor and privilege every day because you can get to help people, you get to help them solve their problems, and you're going to watch this happen today. So we at the Alexander Blewett III School of Law pride ourselves in preparing students for the people-oriented practice of law. Today, you will see many of our graduates at work. One of them will be arguing the case, and 6 of the 7 justices who are deciding the case are also our graduates from Montana Law School. We continue to have high outcomes, so this is for those of you who are thinking of going to law school. We have a 95% bar and placement rate, and we rank in the top 100 law schools in the United States. So if you are interested, please definitely reach out to us. What I want to focus on today is the role of lawyers and our judiciary in protecting us as individuals and the rights afforded each of us under our state and federal constitutions. Today, the case is going to focus on a criminal matter, and a student from our Montana Law Review will be introducing it. But before I introduce her, I want to lay out the big picture of where the court system lies in our checks and balances that our Constitution protects. So the Montana Supreme Court is one of the 3 branches of government. Like the legislature and like the executive branch, the justices and judges in Montana are elected by the people. And as I said earlier, each branch provides a check and balance of the other branches. So if you think of the legislature meets every 2 years in Montana, and it passes laws. And then the governor's office and the executive branch administers those laws. And what you all will be watching today is the court system. The justices of the Montana Supreme Court focus on, I'm seeing even more people come in. I'm so excited that they are here also to hear everything. So let me go back. The justices of the Montana Supreme Court are here to focus on the individual rather than the rights of the majority. And they are here to listen to the case that is being argued and help 2 parties come to a peaceable solution in a very hotly contested matter. So with that as background, I am going to invite Rachel Leader. Rachel is a second-year law student. She is an incoming editor-in-chief of the Montana Law Review. And for the students in the audience who don't know what the Montana Law Review is, it is a journal that helps develop law through a series of articles. And so Rachel has also written an article about this case that you will be able to read when the next journal becomes published. Ms. Leader will provide a high-level overview of today's arguments. She'll focus on the facts, and then she'll outline the arguments and pay very close attention to what those arguments are, because that will help you follow what's being said by the lawyers arguing the case, and it'll help you follow the questions that are being asked by the justices. So please join me in welcoming Rachel Leader.
Good morning and welcome, everyone. My name is Rachel Leader, and I'm a second-year law student at the University of Montana's Alexander Blewett III School of Law. On behalf of the Montana Law Review, I would like to thank Montana State University for hosting this event. I would also like to thank the Montana Supreme Court for traveling to Bozeman to hold this oral argument and for giving me this opportunity to introduce the case before the courts today. We are here today for the oral argument in State of Montana versus J. Stephen Huber. Mr. Huber was convicted of deliberate homicide by accountability and aggravated burglary. He is appealing both of those convictions. I will start by telling you the facts of the case and explain the charges. Then I will preview what you may hear the parties argue today. J. Stephen Huber, the defendant in this case, worked as a bail bondsman. A bail bondsman posts bail for a person in jail so they can be released. In exchange, the person in jail signs a bond contract and pays the bondsman 10% of their total bail. I'll give you an example. If a person's bail is set at $10,000, the arrested person pays the bondsman $1,000 and signs a bond contract. The bondsman posts the $10,000 with the court so the person can be released. If the person does show up for court, then the bondsman gets the $10,000 back and keeps the $1,000 paid by the arrested person as their fee. If the person does not show up for court, the bondsman is out the $9,000 difference. Now back to the facts. As a heads up, there are several people involved in the events that led to this case. You are likely to hear the parties and the courts talk about them by name today. Mr. Huber posted bail for David Sandoval totaling $25,000. David Sandoval signed a bond contract with Mr. Huber. The bond contract said that if David Sandoval failed to appear in court, Mr. Huber had the rights to apprehend him. The contract also said that David Sandoval consented to the use of reasonable force if necessary. In the bond contract, David Sandoval listed 3 possible residences in case he failed to appear in court. One of the 3 residences listed in the bond contract was a house owned by Bill Harris. After posting bond, David Sandoval did not appear in court. As a reminder, this case is not about David Sandoval failing to appear in court. Warrants for David Sandoval's arrest were issued. Mr. Huber went looking for David Sandoval and found him at Bill Harris's home. Mr. Huber could not get David Sandoval to come out of the house, so Mr. Huber called the police for assistance. Police explains that they did not have authority to go inside to retrieve David Sandoval. This is because police typically need a warrant before they can enter a home. However, Mr. Huber is not a policeman, and the police suggested that Mr. Huber might have the authority as a bondsman to enter the house to apprehend David Sandoval. The next day, Mr. Huber returned to Bill Harris's home with other people, including a man named Nick Jaeger. Before entering the house, Mr. Huber called police for help. Again, the police told Mr. Huber they could not assist him. Mr. Huber and Nick Jaeger went inside and announced that they were bondsmen. Bill Harris, the homeowner, and David Sandoval were inside. Bill Harris yelled for Mr. Huber and Nick Jaeger to get out of his house. A fight between Mr. Huber and David Sandoval ensued. They ended up on the ground wrestling, and during the altercation, Nick Jaeger got a hold of Mr. Huber's gun. 2 gunshots were fired. Nick Jaeger fatally shot Bill Harris. Mr. Huber was arrested and charged with deliberate homicide by accountability and aggravated burglary. The state of Montana prosecuted him on these charges. To follow what the parties may argue today, it will be helpful to understand the charges. First, Mr. Huber was charged with deliberate homicide by accountability. Deliberate homicide by accountability holds a person liable for helping another person commit murder. In this case, Mr. Huber was not charged because he fired the gun that killed Bill Harris. Mr. Huber was charged because he helped, assisted, or aided Nick Jaeger, who fired the gun that killed Bill Harris. Second, Mr. Huber was convicted of aggravated burglary. Burglary is broader than breaking into a home and stealing something. In this case, it required entering a home without permission, committing a crime inside the home, and hurting someone while inside. That leads to the question of what mental state a defendant must have to be convicted of a crime. To be convicted, a defendant must have acted with a specific mental state. In other words, a defendant must act with criminal intention as opposed to acting accidentally. The law calls the mental state mens rea. In Montana, mens rea is defined as acting purposefully or knowingly. To understand what purposefully or knowingly means turns on an important distinction. That distinction is whether the crime is conduct-based or result-based. Conduct-based looks at a defendant's actions. Result-based looks at the outcome of a defendant's actions. That means for deliberate homicide by accountability, a result-based crime, the state had to prove that Mr. Huber intended to give Nick Jaeger the gun so Nick could kill or harm someone. For aggravated burglary, also a result-based crime, the state had to prove that Mr. Huber intended to enter a house without permission and to harm someone while inside. The jury convicted Mr. Huber of both charges. Mr. Huber's grounds for appeal can be described in 2 broad categories. First, his appeal is based on the jury instructions as to his mental state. Second, his appeal is based on his status as a bondsman. I'll address them each in turn. In a criminal trial, the judge gives an instruction to the jury on the mental state the jury should be looking for. This jury instruction is based on what the parties' lawyers propose. On appeal, the parties are arguing about whether the correct jury instruction on the mental state was provided at trial. The jury instruction at issue matters most for the charge of deliberate homicide by accountability. For deliberate homicide by accountability, the state had to prove that Mr. Huber intended to give Nick Jaeger the gun so he could shoot Bill Harris. Instead, the jury was instructed that the state had to prove Mr. Huber gave Nick Jaeger the gun without regard to the outcome. During the trial, Mr. Huber's lawyer did not object to the mental state instructions. On appeal, both parties seemed to agree that the instruction given at trial was incorrect. Today, Mr. Huber may make 3 arguments related to the mental state instructions. First, Mr. Huber's lawyer did not object during trial. He may argue that the incorrect mental state resulted in what is called a plain error due to this failed objection. A plain error means, essentially, it was extremely unfair. A plain error is a very high burden on appeal. Second, Mr. Huber may argue that his lawyers at trial were ineffective because they failed to object to incorrect mental state instructions. Third, Mr. Huber may argue a consequence of the mental state instructions was that the state did not have sufficient evidence to prove Mr. Huber guilty of deliberate homicide by accountability. In response, the state may argue that the mental state instructions did not result in a plain error. Similarly, the state may argue that there is sufficient evidence presented to the jury for a conviction. In response, the state may argue that the mental state instructions, Mr. Huber's second ground for appeal stems from his belief that his status as a bondsman negates his criminal liability. Nationwide, there is a legal dispute over whether a bond contract gives bail bondsmen the right to behave in ways police cannot. Some courts across the country have held that a bondsman can enter a home without permission to apprehend someone who failed to appear in court. This is referred to as a bondsman privilege. Before the trial was held, the trial court denied Mr. Huber the opportunity to assert or instruct the jury on a bondsman privilege. Today, the parties may argue whether there is such thing as a bondsman privilege in Montana. Mr. Huber may argue that a bondsman privilege exists in Montana, and the Montana Supreme Court should adopt the approach of other courts around the country. In response, the state may argue that no bondsman privilege exists under Montana law because bondsmen cannot have more authority than law enforcement. Short of that, and going back to the mental state, Mr. Huber may argue that his status as a bondsman negates his criminal mental state. Mr. Huber may argue he genuinely believed he was entitled to enter Bill Harris's home since it was listed on David Sandoval's bond contract. If that was the case, then Mr. Huber may argue he lacked the intent to commit both deliberate homicide by accountability and aggravated burglary. Instead, he may argue he was following the terms of the bond contract and working to return David Sandoval to court so he could get his money back. In response, the state may argue that a bondsman privilege should not allow a bondsman to escape liability for burglary. Even if there is such thing as a bondsman privilege, the state may also argue that the privilege cannot permit a bondsman to enter a third party's home to make an arrest. The state may argue how Mr. Huber did not enter David Sandoval's home to apprehend him. He entered Bill Harris's home, so no bondsman privilege should apply. You may also hear the parties argue about whether bondsmen are more like law enforcement or more like private citizens? If bondsmen are more like law enforcement, they're subject to similar constitutional restraints as the police. If bondsmen are more like private citizens, they are not subject to the same constitutional restraints as police. We are here today for oral argument before the Montana Supreme Court. Oral argument is different from a trial, where the parties call witnesses and present evidence before a judge and a jury. Oral argument is more like a conversation between the lawyers and the justices of the court. The justices have already reviewed the record from the trial court and the parties' written briefs. The party that brings an appeal after losing at the trial court is called the appellant. Mr. Huber is the appellant in this case. The party that won at the trial court is called the appellee. In this case, the state of Montana is the appellee. In this oral argument, you will first hear from the attorney for Mr. Huber. Then you will hear from the Assistant Attorney General representing the state of Montana. Mr. Huber's counsel will give a rebuttal following the state's argument. After the oral argument, the court takes the arguments under advisement. The justices will deliberate and discuss the issues. In the coming weeks and months, they will issue their final written opinion. This concludes the introduction. Thank you again to the Montana Supreme Court for giving me the opportunity to introduce this case on behalf of the Montana Law Review and the University of Montana's Alexander Blewett III School of Law. Thank you.
Good morning, everyone. Good to see a large crowd here today. This is the time set for the oral argument in cause number DA 24-0386, State of Montana versus J. Stephen Huber. I'm going to briefly introduce the members of the court and then ask counsel for both sides to introduce yourselves before we begin the argument. Beginning on the left, Justice Jim Rice. Justice Jeremiah Shea has recused himself from this case. District Court Judge Christopher Abbott from Helena, 1st Judicial District, is sitting in his place. Justice Lori McKinnon is here. My name is Corey Swanson. I'm Chief Justice. Justice Ingrid Gustafson is next to me. Justice Beth Baker, farther on the right. And then Justice Catherine Bittigary on the far right. Counsel, you want to introduce yourselves, please?
Good morning. My name is Palmer Hubestall. I'm an attorney from Helena.
Howdy, my name is Colin Stevens. I'm an attorney from Missoula and Becker.
And counsel, are you splitting time?
Yes.
Okay. And then counsel for the state?
My name is Mardell Ployhar, and I am the Bureau Chief of the Appellate Bureau in the Attorney General's Office.
All right. So not sure everybody can hear that. So Mardell Ployhar for the state and for the appellant Palmer Huvestal and Colin Stevens. You may proceed.
Thank you, Your Honor. Good morning, and may it please the court. I was trial counsel in the district court below. Mr. Stevens and I are going to break up our argument in 2 segments of 15 minutes apiece, and then we're going to reserve 10 minutes for rebuttal. I'm going to begin with the bail bondsman issue. Back in 1982, when I attended Montana State University, I lived in a trailer in a mobile home park on College. I did not own the trailer. I lived there with some other students. I didn't sign a lease agreement, but I slept there, I ate there, I kept my possessions there, and I received mail there. I bring this up to illustrate the point that is important in this case, that it is entirely possible to reside someplace, to live in a home without owning it. And the issue of whether David Sandoval lived at 815 South Main on December 19th, 2021 was a jury question. It was a jury question that had to be decided by the jury based on a number of different facts that we'll probably get into a little later. The question and the error that we assert occurred in the district court below was Jay Hubbard's source of authority for entering into 815 South Main, which was owned by William Harris. Jay Hubbard had three sources of authority. The first one was statutory. The second was common law. And the third one was by application of the bail bond contract between Mr. Hubbard and Mr. Sandoval. Compounding that authority was the factual truth that two district court judges, well, I think maybe it was the same district court judge in retrospect, Judge Whalen, issued arrest warrants for David Sandoval's arrest. And I think that there was a city court judge who also issued an arrest warrant for Mr. Sandoval. And so the fact that there were arrest warrants out for Mr. Sandoval's arrest, and the fact that Mr. Sandoval identified 815 South Main as his residence, or at least a place where he lived on the bail bond contract, the day prior to the events of December 19th, when Mr. Harris was killed, on December 18th, 2021, Jay Hubbard saw David Sandoval at 815 South Main. He saw him, he went in, and he detained him.
Excuse me, counsel, good to see you. You rely on the bail bond contract as authority, and it seems like in the record it's undisputed that Bill Harris owns this property. He's not a party to the contract. How can a bail bonds contract to which he's not a party vary his right to privacy in his home or constitute consent for someone to enter his home?
Well, he clearly allowed David Sandoval to be there. Again, it was a factual question that the jury had to decide. He spent a lot of time there. He spent the night there. There was ample testimony that he was there the day before. It was a trap house where people used drugs. And so, and I would point the court to the Stegall case. It's the United States Supreme Court that was, United States Supreme Court case that was cited in a briefing. But importantly, we're talking about the dissent of Justice Rehnquist and Justice White. In their dissents, they talk about, Justice Rehnquist wrote it, he talks about the right of a third party, or the right of a law enforcement officer in that particular case to enter a third party's house. And he talks about whether the person lived there for a day, or he lived there for a week, or he lived there, full time. And so the point that David Sandoval actually lived at 815 South Main and that Mr. Harris allowed him to be there, that makes a huge difference when it relates to Harris's expectation of a privacy interest in his home. So
Wasn't that issue was addressed in factual testimony in front of the jury. For them to find aggravated burglary, they have to find he entered or remained unlawfully in the residence. And even if your argument was correct, at the point when Harris says, "Get the F out of my house," why does Huber or his colleague think that they still have permission to be in the home?
Because it's not like Mr. Harris was standing at the front door saying, no, you can't come in. Mr. Harris was standing in the back bedroom saying, you can't basically arrest David Sandoval. He wasn't trying to prevent anybody from coming into his house. He was trying to prevent.
Didn't he tell him to leave several times?
Pardon me?
Didn't he tell him to leave several times?
He did.
I mean, the transcript is just filled with times where Mr. Harris, as the owner of the house, told him to leave.
That's correct. But he said leave, not with the purpose of, protecting his own privacy interests in the house. He said to leave because he didn't want his friend David Sandoval to be arrested. He also said, you're not going to jail.
Well, but it's his property, and he can tell people to leave, right?
He can certainly tell people to leave, but his property isn't sanctuary for fugitives to hide.
But in that, so you're analogizing, in the brief, you're basically saying Harris was interfering with an arrest.
Correct.
Okay, law enforcement didn't make the arrest because they didn't go get a search warrant to enter the home. They've got the arrest warrant, but they didn't get a search warrant to enter the home. So you're asking us to basically empower Mr. Huber and his colleagues who just left the bar. I mean, there's all kinds of problems with this assertion that they've fully enjoyed a privilege that's beyond what law enforcement can do. That's before we even get to the arrest. The entry, number one, and then remaining in the home when they're told to leave, number two. Those are before you even get to they're before you get to the tasing and the shooting, it sounds like.
Well, he wasn't there to search. So we look at the cases, and there's a case that hasn't been cited in the briefing, but it's State v. Cow, and I can provide that citation to the court later. But if we go back to Stiegald and those cases that were cited there, those cases involve a search by law enforcement. They had an arrest warrant, but they go into the house for the purpose of searching. What we're talking about here, Jay Huber walked across the street and he saw David Sandoval through the window. He knew that Sandoval was there. So to any extent that the Fourth Amendment protection against unreasonable seizures applies, the arrest warrant was specific. You're going to seize David Sandoval.
Well, except that Stiegald, I mean, the reason why they need to get a search warrant in Stiegald is because since it's not his home, the entry into the home is a search.
Right.
Even if you know he's there. And it's the same thing if cops come up to your house and they see you committing a crime in the window, assuming there's no exigency, they still have to go get a warrant. Even if it's right there, they can't just cross the threshold and say, well, we saw it, we know for a fact there's evidence, that's good enough. So I have a hard time understanding why you wouldn't still need a warrant, if you're law enforcement, to go into this home, even if you quote unquote know he's there. That just means you're likely to get the warrant, not that you don't have to go and try.
Well, with respect to Stiegald, Judge Abbott, I respectfully disagree. If you look at footnote 7 of Stiegald specifically cites Peyton v. New York. Peyton v. New York expressly states that law enforcement has the right to enter a fugitive's home for purpose of arrest without a search warrant. An arrest warrant satisfies that. And that's from Peyton v. New York. And so in this case, we have 3 arrest warrants. Hubbard sees him. He knows that he's in there. He doesn't force entry. He doesn't barge in. He doesn't kick the doors down. The door is open for him. They walk in. Nick Jaeger says, we're bondsmen. We're here to arrest David Sandoval. He sees Sandoval sitting on the bed. He walks over. Sandoval punches him in the face. And then he engages in reasonable force to arrest David Sandoval. And so his entry was lawful. His entry did not exceed the scope of what law enforcement can do.
So you're asserting that because he thinks that somehow your client thought he lived at that house.
Correct.
But didn't he call law enforcement and say he'd run off to this house, and law enforcement told him you don't have any authority to go in that house?
That was a different house, Your Honor. And he did not go into the house. That happened the day before. So he arrests Sandoval, takes him out. Sandoval escapes into a different house. And so he calls law enforcement. He calls Officer Tim McMahon with the Butte Police. McMahon and his partner come, and Mr. Hubbard, and incidentally, his name is pronounced Hubbard, not Huber. He speaks with Officer McMahon, and he says he's in there. And McMahon says, well, we don't have authority to enter without a warrant.
So let me stop you right there.
Pardon me?
Let me stop you there for a second. Is it your position that the bail bondsman's authority is coextensive with that of a law enforcement officer or exceeds that of a law enforcement officer?
Law enforcement has, there's a statute that says law enforcement has the authority to arrest if an arrest warrant is issued, okay? And so the statute that is at issue here is 469510, subparagraph 1B, which expressly states that a bail bondsman or the surety can arrest the defendant. And so I think statutorily, there are two separate grounds for arrest. Law enforcement can do it pursuant to an arrest warrant or, exigent circumstances with probable cause and so forth. But statutorily, law enforcement can do it on that basis. A bail bondsman, it says simply 5101B that a bail bondsman can arrest the defendant. There's no...
So it says nothing about entering a person's home, that statute. So that's what I'm getting at in terms of the extent of the authority vis-a-vis that of law enforcement. What in that statute gives the bail bondsman the right to enter a person's home?
Well, I think that statute is silent. And so when we're talking about the bail bondsman privilege, which is derived from the common law expressly says that a bail bondsman can enter. Judge Christensen and Mitchell in the Mitchell case expressly held, granted this is in federal court, but he expressly held that there is a bail bondsman privilege in the state of Montana.
So I want to ask about that because I don't know if I necessarily agree that the common law in Montana is as established as that. The case that was cited, I think, by Judge Christensen in State v. Bozeman from 1892, that case doesn't have anything about, it might say there's a privilege to arrest, that exceeds that of a private person. It doesn't say anything about breaking into someone's house or making an entry to effect an arrest or going on someone's property to make an arrest. Likewise, Taylor v. Trainter, which is the U.S. Supreme Court case, it has a statement about that, but that case isn't about that. And it's, 100 years before the Fourth Amendment even applied to states.
Right, but still, it talks about what occurs when a bail bondsman, the bond is a guarantee that the principal will show up. And because it's a guarantee, the principal loses certain rights, and those rights are the right to, object to being arrested, being taken into custody.
But even if the principal does lose some of his rights by virtue of the contract that he signs with the bail bondsman, which is essentially a surety insurance agent
Sure.
for an insurance company that's actually putting up the money, in your own brief on page 3, you say that the contract that Mr. Sandoval signed listed 3 addresses for Sandoval. First was his mother's house at 1230 West whatever. The second was another, and then the third was this address that's at issue. And then it says, Sandoval did not fill out the address portions and was unsure if he gave his this last address to Hubbard. The pretrial supervision person, Verlandic, apparently is the one that provided that address. So how could, under those circumstances, which even in your own brief you say he didn't provide the addresses, how could Mr. Harris, whose house they entered, be subject to that contract?
Justice Bigary, the testimony is that Mr. Sandoval did in fact provide that address to Mr. Hubbard. Mr. Hubbard testified to that.
Is there any evidence that if that were established, even though that's not what you say in your brief, if that is what was established at trial, There's no evidence that Mr. Harris, who actually was the owner of the home that your client entered, knew about that contract or had in any way lessened his reasonable expectation of privacy in his own home.
Well, he knew that Sandoval was a fugitive, and he knew that Sandoval was in his house. He knew that the cops were after him. He knew that Mr. Hubbard was after him. And so it was unlawful. It was an obstruction of justice for him to harbor a fugitive there. And so I think that his expectation of privacy didn't go as far as to allow him to provide sanctuary. And again, I would point the court to the dissent in State v. Siegel. So I see that my time has gone beyond the 15 minutes. I'm going to yield the podium to Mr. Collins.
Good morning, Your Honors. May it please the court. While I get set up here, I want to give the court a historical example of why I think the jury instructions in this case are so important. And we'll go back a bit. So in the year 1170, King Henry II, in a fit of frustration, was heard to yell out, "Will no one rid me of this turbulent priest?"
Meddlesome.
Meddlesome. I actually Googled it, Mr. Chief Justice. It's a little bit, but we'll go with meddlesome. Either way, it was not a flattering description. So in response, 4 of Henry's knights set out for Canterbury Cathedral, where they proceeded to murder the archbishop. Now, if King Henry was tried and could find a fair and impartial jury in the Irish enclave of Butte, America, the state would have to prove beyond a reasonable doubt that not only was King Henry aware of his conduct, i.e., will no one rid me of this meddlesome, turbulent, troublesome priest, that he was uttering those words, but he actually intended the result to have those 4 idiots ride out to the church and kill the priest. And absent that second requirement, the state's burden is lessened, and that's exactly what happened in Mr. Hubbard's case. So whether it's ineffective assistance of counsel, whether it's plain error, Mr. Hubbard's case has to be reversed on this instructional error. The reality is that the state's burden on the critical mental state element was lessened to both aggravated burglary and to accountability for deliberate homicide.
I don't mean to cut your argument short, counsel.
Please do, Justice Rice.
And it's Mr. Stevenson, right?
It's just Mr. Stevens, Your Honor.
Okay. I know you're going to get to harmless error, but I mean, that's obviously an issue the court's going to be considering very seriously. The state argues that, well, yes, there was this error in part of the instructions, but part of them were correct too. And when you consider the fact that this offense was an offense that the result was inherently part of the conduct, then the distinction between result-oriented and conduct-oriented instructions is not that significant in this case.
So I'm going to disagree with you there, Justice Rice, and I do, the state leans heavily into this sort of after, therefore, because argument, and again, I would note that it's a fallacy, right? Just because 4 idiots rode off and killed the Archbishop, Thomas Becket, doesn't mean that that's what King Henry intended, and that's a huge burden lessening issue here. But what I will tell the court is purposely, which is the incorrect instruction, it applies to every element of the offense to which purposely is included in the legislation. The jury is presumed, it's a maxim of jurisprudence, the jury is presumed to follow the law, which means that every time the jury encountered the word purpose or purposely in those instructions, it applied the wrong definition, the wrong standard, whatever you want to call it. And so to me, it cannot be harmless error if you have a jury that is reading the instructions, and I think there's 4 or 5 times in the instructions where the court specifically just says, this is the law you're bound to follow. So you have the jury that you presume that the jury reads purposely in the incorrect way every time it appears in those instructions. I don't see how that can be harmless error.
Well, it it's not, just to clarify, the standard here isn't harmless error, but plain error. And there's a pretty big distinction there. Do you agree?
Absolutely. And I will add, Justice Baker, that we also throw in the ineffective assistance of counsel, which I think under any standard, be it plain error or be it, under the Strickland prongs, Mr. Hubbard was prejudiced, and there's more to plain error than just the manifest miscarriage of justice. And I will credit the state that its spotlight on the plain error elements is solely focused on the manifest miscarriage of justice aspect. But this court can invoke plain error for other reasons, and that is, whether the error calls into question the integrity of the proceedings or whether it, undermines the court's confidence in the verdict.
Right. And similarly, in the ineffective assistance standard, I mean, we're really looking at whether there's a reasonable likelihood that the outcome would have been different. So what in the record supports an argument that there's a reasonable likelihood the outcome would have been different here with this one definition being changed?
Yeah, so I think, I don't mean this to be glib, Justice Baker, but I would say almost the entire record does. Because you have a situation where Mr. Hubbard's on the floor, he's getting kicked and beaten, he's in this sort of scrum with Mr. Sandoval, and the testimony is he can't hear anything, he's just myopically focused on sort of this melee. And then you have Mr. Jaeger, who sort of is completely privy to all this other stuff that's happening. Mr. Harris, with a bottle or the scissors in the bedroom. And then he gets the gun. And the reason purposely matters is, and why I think there's a reasonable probability that but for the error, the result would be different, is it just hammers the nature of what the result had to be, that Mr. Hubbard had to have had basically the intent to have Mr. Jaeger kill Bill Harris.
So counsel, if I could ask, without focusing on the mens rea instruction, how was the jury instructed? They were not instructed as to the bail bondsman issue. Is that correct?
Correct, Your Honor.
It did not play any role in the jury instructions?
Correct.
How did it play out during the trial?
How did the bondsman issue play out during the trial?
That's right.
The jury heard testimony mostly from Mr. Hubbard that, about his education, his training, what his purpose was to go into the house. I think there's numerous references to his intent to go in and arrest Mr. Sandoval. And that was based on the district court's decision that, okay, well, defense can't offer the bondsman argument, but I'm going to give you this, private citizen arrest instruction. So that's in essence how it played out at trial, Justice McKinnon.
Counsel, I have a question about, you mentioned, talking about the result, and here, of course, we have a nested offense because we have an accountability theory for deliberate homicide. And so there's a purpose to facilitate the commission of the offense. One of the cases, I don't remember who cited it, was State v. Lantis, which kind of suggests that isn't necessarily a purpose to facilitate the death, but a purpose to facilitate the reckless conduct or conduct likely to result in death. And I'm wondering what you think about how that affects your argument about whether this is truly a result-based or what the relevant result is.
I think Lantis is kind of a wonky case, Your Honor, and at the end of the day, what the argument seemed to be in Lantis was more of a cause and result. So the defendant in that particular case, I think the victim died of strangulation, and the defense wasn't, I knew I was in this melee, although there was some evidence of that, but the defense really turned on, I didn't mean for him to die by strangulation, right? Maybe it was I meant him to die by stabbing him repeatedly with a pen, which is what happened also to the victim in Lantis. But Lantis is just distinguishable in the sense of the argument that was presented to this court and the facts. And really what you have here, instead of what occurred in Lantis as, well, I didn't maybe mean for him to die that way, the jury instructions really precluded Mr. Hubbard from saying, I didn't mean for him to die at all. I was aware of my conduct. I was aware that I was rolling around on the floor, that we went into this house, privileged or otherwise. But I didn't mean, facilitate, agree that a death should occur while we were in this house. That was not my intended result. So I think that's how I would distinguish Lantis, Judge Abbott. I do just think I think that the decision, or the holding that the state wants to take from Lantis is probably a bridge too far from really what the actual holding is.
What about the state's point that if we take your argument, then the district court basically has to provide every definition of knowingly, but as applied to a particular line in an offense, and that jurors are going to be hopelessly confused as to what to do with it, which, I think that's part of the problem we have anyway. I mean, lawyers and judges are struggling with this. I don't know that jurors get it at all. So rather than the state basically saying if it's a result-based offense, you do this. If it's a conduct-based, you do this as a single instruction. And since knowingly was correct, not a big deal. The purposely is generally a higher burden, I think, than knowingly. So what's your response there?
Well, I do definitely love that it's a higher burden than knowingly for the state. I think my response is that that fear by the district court judges, and it comes from, I think, the commentary in some of this court's decisions where previously courts had given kind of the king's table smorgasbord instruction, right? Knowingly is defined as A, B, C, or D. And the court justifiably said, you can't do that. But nowhere has this court said that district courts should not be instructing as to what specific definition applies to what specific element. And really, it would be somewhat easy to do and to minimize confusion to jurors to essentially say, all right, so for, let's take aggravated burglary, for example. Knowingly as to aggravated burglary means X. Purposely within accountability means Y. I think you can build it into the instruction and actually create.
Your brief says that even aggravated burglary has, 3 different definitions of knowingly?
Yeah, that statute's a mess. It's a terrible statute, with all respect to the legislature. But yeah, I think you could build in an instruction that says, with respect to element entrance, knowingly is defined as this. With respect to intent to commit an offense therein, purposely is defined as conscious object to commit that offense.
So I feel like I'd be remiss if I didn't ask this, because when I've wondered about the meddlesome priest and jury instructions, I've often felt it's Lambert and Azure. How would it negatively impact defendants if district courts just read the statutory definition like we do in any other set of instructions, and just say, when you're talking about a fact, here's the definition of knowingly. When you're talking about a result, here's the definition. Here's conduct, and trust the jurors can distinguish between what we mean when we say conduct, result, and fact.
I mean, Judge Abbott, that's obviously a bigger conversation than why we're here. But what I will say is there's an emerging trend sort of in the academia to maybe start moving away from this model penal code definition, that it's served its purpose. But I mean, I don't think, Your Honor's suggestion is unreasonable. I just think it's not the way the instructions are crafted now.
Even without the homicide conviction, the ag burglary conviction, I mean, multiple people are injured in the course of that. And he's got all this testimony. We've already asked your colleague about all this testimony about people saying, get out, you can't be here, et cetera. I'm trying to figure out how the instruction would overturn that conviction.
The ag burglary?
Correct.
That's a more difficult one. I will absolutely concede that, because the beginning of the statute just says knowingly, and the knowingly was the appropriate instruction that was given in that case. I do think, though, that gets us back to King Henry about the instruction then goes on to say, and purposely commits an offense therein. And again, this is where it really dovetails with the bondsman argument, because not only does Mr. Hubbard have to be sort of aware that his entrance is unlawful, setting aside the fact that Mr. Harris potentially then said, you're remaining here, it becomes unlawful, but there has to be the intent to commit the offense in there. It can't just be conduct, you were aware of your conduct, and that's it. It was your conscious object to engage in this conduct. It had to be your conscious object to commit an offense therein after knowingly entering or remaining unlawfully. If there are
Any further questions for counsel? Thank you.
I will reserve. Thank you, Mr. Chief Justice.
May it please the court, my name is Mardell Ployhar. I'm here on behalf of the state. Mr. Hubbard's convictions for deliberate homicide by accountability and aggravated burglary should be affirmed for 4 reasons. First, Mr. Hubbard's argument that more than one mental state instruction should have been given for aggravated burglary should not be reviewed under the plain error doctrine because Mr. Hubbard has failed to demonstrate that the alleged error is plain or that he was substantially prejudiced by the instruction that was given. Second, although the incorrect definition of purposely was given, that claim should not be reviewed under the plain error doctrine because Mr. Hubbard has not demonstrated that he was prejudiced by that definition and the jury was correctly instructed on the elements of the offense. Third, there was sufficient evidence from which a rational trier of fact could find that Mr. Hubbard was accountable to deliberate homicide beyond a reasonable doubt when viewing the evidence in the light most favorable to the state. And fourth, the court did not abuse its discretion when it refused the jury instructions proposed by Mr. Hubbard on the bondsman privilege because he did not have the authority to enter Bill Harris's house to arrest Mr. Sandoval. I'd like to begin by addressing the mental state instructions. None of Mr. Hubbard's arguments regarding the mental state instructions should be reviewed under the plain error doctrine. Plain error review is to be used sparingly on a case-by-case basis. The party seeking review has the burden of demonstrating, 1, that a plain or obvious error occurred, 2, that alleged error implicates a fundamental constitutional right, and that 3, the alleged error will, if not corrected, result in a manifest miscarriage of justice or prejudicially undermine the fundamental fairness of the proceeding or compromise the integrity of the judicial process. For the first time on appeal, Mr. Hubbard has argued that a separate knowingly or circumstance instruction should have been given for the first element of aggravated burglary. That element requires that Mr. Hubbard knowingly entered or remained unlawfully in an occupied structure. This claim should be rejected under the plain error doctrine because this court has repeatedly held the courts may not give multiple mental state instructions and require the jury to determine which applies.
Well, counsel, what happens though when you have, so I'll just take aggravated burglary as an example. You have the first thing is enters or remains, that's conduct. Unlawfully, which is usually going to be acknowledged as to a fact, the fact that you're not welcome. And then with the purpose to commit an offense, if it's charged that way. And so that's going to often be a result. So you have 3 different, so you have ag burglary, and then you have, in this case, the way it's charged is attempts to inflict bodily injury, and attempts requires purpose, again, as to result. So you have conduct, you have fact, you have result. How are we accurately instructing a jury as to what the statute says if we don't read them all 3 of those definitions? Just because, there's some case law that has tried to correct by saying you should only read 1.
I understand that complexity, Your Honor. I think what's really significant here is that we are reviewing this under the plain error doctrine, and this court has not required courts to divide out each element of an offense. And
well, I'm wondering if you can still address the merits of it, though, of my question. I understand the plain error argument, and that's separate. I'm just curious about the merits about this. What is error?
How this court has looked, I do not believe it is error, even if this was reviewed solely, even if it wasn't under the plain error doctrine, because how this court has viewed the issue is, what this court has instructed is to look at the elements overall and treat the offense as either a conduct-oriented offense or a result-oriented offense. So if this court is going to continue with that approach, then the instructions given were not, the instruction on knowingly was not incorrect in this case. And I have a couple of examples. I mean, one would be in State versus Roe. This court held that it was error to give both the result and the conduct definition of knowingly for sexual assault, even though sexual assault requires sexual conduct, and sexual conduct contains result-type elements. Despite that, this court still said, overall, this is offense we have decided is criminalizing conduct, and therefore that's the only one you can give. Another example would be this court recently reversed in State versus Hammernick, where the district court in that case, that was a case involving sexual intercourse without consent. The district court determined that without consent is its own element, that its own determination that should be made, and instructed separately on it. This court held that was error, and that the only instruction that could be given is conduct. So,
Counsel, I don't think that the law, I think what, in answer to what Judge Abbott asked, we can, the district courts can instruct on multiple mens reas. It's that you cannot let the jury pick which one. It can't be an or. You can have 3 different mens rea instructions on one offense, but you can't let the jury select which mens rea to apply. You can't give them the cart and say, pick something out of it.
well, I agree with that, Your Honor, but I guess the examples that I'm providing, I think, also show that this court has not parsed out every single potential element and said that they need to be instructed on. That's not consistent with what this court's cases have done. Therefore, Mr. Hubbard in this case cannot demonstrate that any error was plain. I mean, if this court wants to, in the future, advise that instead I acknowledge burglary is a complex statute. If this court wants to advise that instead courts should look at the first element and instruct on a mental state that goes to that, I don't object to that, but I don't think we can say in this case, where Mr. Hubbard didn't propose any mental state instructions, that it was plain error for the court to give the result-based knowingly instruction.
So same argument applies to ineffective assistance?
Absolutely, Your Honor, yes. The same argument applied to ineffective assistance. We can't say the counsel is deficient in this case for not offering a separate instruction when that's not what this court's case law requires.
So, counsel, so as far as whether the error is plain, the first element, I mean, there's a concession on both sides that I think with respect to purposely, there was error in that instruction.
Yes, Your Honor.
So
Yes.
the error is plain. We all agree there's an error.
Yes.
With respect to the second element, does it, affect the fundamental, fairness of the proceedings? Isn't in a situation where you have Mr. Hubbard, who there's no dispute that Nick Jaeger is the one who shot Mr. Harris. There's no dispute that Mr. Jaeger wouldn't have been able to shoot him if Hubbard hadn't brought a gun, hadn't broken into the house, hadn't enlisted him. Isn't the only thing that separates innocent or guilt whether Hubbard had the purpose to facilitate the commission of the offense when you're doing an accountability theory? I mean, isn't that the thing that separates this conduct from innocence and guilt? Is whether he actually had the purpose that Nick Jaeger's do some act, or depending on how you characterize that result, or cause the death of him. And so, I mean, it seems like this is not a sort of case where, yeah, we have the mental state, but if they engage in the conduct, it's clear what their mental state was. There is a dispute here about what that mental state would have been.
I do agree, Your Honor, that for purposes of not aggravated burglary, I think for aggravated burglary, the evidence is overwhelming under any definition. I do agree that for the purposes of accountability to deliberate homicide, the mental state was critical to that. So I agree with that. But nevertheless, the jury was never instructed. What they were instructed is that, on the conduct-based definition, is that a person acts purposely when it is a person's conscious object to engage in conduct of that nature. But they were never instructed that this person doesn't have to intend the result. That was an instruction given in Rothacker. Like, that would have been an entirely different situation. I think we need to look at how jurors are going to read these jury instructions. So when a juror is instructed that a person acts purposely when it is the person's conscious object to engage in the conduct of that nature, it's not rational for jurors to think then that as long as the person is aware, they have the intent to cause whatever conduct they happen to be doing, no matter what it is, that they're going to be guilty of this offense. Instead, that definition has to be read along with the elements of the offense. And the elements required that Mr. Hubbard either before or during the commission of an offense, and with the purpose to promote or facilitate such commission, that he solicited, aided, abetted, agreed, and I think it's really, aided and abetted here, the other person in the planning, and I don't think it's the planning in this case, but the planning or commission, it's the commission of the offense. So the jury instructions required the jury to find that Mr. Hubbard had the purpose to promote or facilitate such the commission of the offense.
But counsel, if they're just read a conduct-based definition, we have to presume they're going to try to follow the court's direction. It says that all they have to do is aware of their own conduct. And they say, well, him getting in the scrum with the gun with a defective holster, if you take the, I think, defense-friendly version of this, is, that's his conduct and facilitated. I mean, I can see how a juror might say, well, it just says he has to be aware of his conduct. He went in there knowing this could happen, and that's the purpose to promote. I mean, that's the problem with instructing on just the conduct definition.
Well, the state's position is that's not how a rational juror would read these instructions. The rational juror is going to focus on the elements that still require the purpose to aid and abet this offense. They're never told that this person doesn't have to consider the result or the result doesn't matter. And they're not even understanding that there is a potential result instruction out there that wasn't given. They're just told that, given this instruction that purposely relates to having this conscious object to engage in conduct of this nature. But to understand what the conduct of the nature is, we have to go to the elements that require the purpose to aid or abet in the commission of a deliberate homicide. So our position is that in this case, the jury would not have misunderstood that. And it is significant, again, going back to plain error, that to prevail, Mr. Hubbard has to demonstrate that failing to review the issue under the plain error doctrine would result in a manifest miscarriage of justice. So some potential that the juror may have misunderstood is not going to be enough to meet that burden. I do want to address the sufficiency of the evidence for the, because that relates again to the sufficiency of the evidence for the deliberate homicide by accountability charge.
I'm sorry, before you leave that instructions, I just want to hearken back to one comment that counsel made, that the instructions precluded the defendant from being able to argue that he didn't intend for anyone to get shot or for Harris to get killed. So is there anything, I mean, I think your last comment kind of addresses that we have to look at how a rational juror would have viewed that. But do you think the instructions precluded that argument?
Thank you, Your Honor. Absolutely not. I do not believe that anything, there was no limitation on what Mr. Hubbard could argue about what his intention was. So, no, I don't believe he was in any way limited on his ability to argue about what was required by these instructions or what mental state he had.
Counsel, how much did the bail bondsman issue play into that, his argument?
Well,
I know you're going to get to that issue if you'd rather address it.
I can get to it right now,
Okay.
too. I'd be happy to address that. But maybe, I guess, just to clarify, how much did it play into his?
To me, that's the critical issue in this case, is whether he had, what type of authority, if any, did he have to go into the house? And then, so the district court equated his authority with a citizen. We've got statutes that provide for more authority than that. I guess I'm asking, did the jury get to hear any of that evidence?
So the jury heard evidence from Mr. Hubbard, and there were a couple of other bondsmen that testified. So they heard evidence about the job of bondsman. It was very clear from the evidence that a bondsman's job is to, after somebody's bail has been forfeited, is to attempt to arrest that person and bring them into jail. The district court did refuse to give the instructions proposed by Mr. Hubbard on the bondsman privilege. And I think it also helps to look at how this all developed. Originally, this was raised pre-trial by Mr. Hubbard. He filed a motion to dismiss the aggravated burglary charge, arguing that he couldn't have committed aggravated burglary because he was a bondsman. Never in that motion did he ever suggest that he actually believed that Mr. Sandoval lived in that house. Mr. Hubbard provided an affidavit in support of his motion to dismiss. He didn't even mention this house in the affidavit, so there was no allegation in there that he actually believed that Sandoval lived there. Instead, his argument was that as a bondsman, he had the right to go and arrest Mr. Sandoval wherever Mr. Sandoval was. And the district court rejected that based on the district court's conclusion that this was Mr. Harris's house. Mr. Harris didn't do anything to give up his right to privacy, and Mr. Hubbard, as a bondsman, did not have the authority to go into Mr. Harris's house. Then at trial, Mr. Hubbard proposed a series of instructions that related to the bondsman's privilege. The district court rejected all of those. Some of those instructions set out sort of the general law of forfeiture of bail. One of them was about the return of a bail bond after conviction. That was not relevant in any way. One of them related to the use of force to resist arrest, to try to argue that somehow because Sandoval was resisting arrest, somehow that mattered. That also did not. That was very appropriately rejected by the district court. One instruction that did go directly to the authority of Mr. Hubbard and his actions that was proposed was instruction number 12. Instruction number 12 was based on the language of Montana Code Annotated 46-9-510, and this would have stated that a bail bondsman may arrest the defendant and surrender the defendant to the court. So it was requested by Mr. Hubbard that he receive that instruction. The district court again refused that instruction because there was no evidence that Mr. Harris ever allowed Mr. Sandoval to live in the house. Instead, the evidence was to the contrary. People testified that Mr. Harris would let Sandoval hang out until Mr. Harris told him to go home. So, and Mr. Hubbard himself never testified that he actually believed that Sandoval lived in this house. So the evidence did not support that instruction, and the district court therefore refused it. Had the district court given it, it had the great likelihood of misleading and confusing the jury if the jury could not have simply been advised that Mr. Hubbard had the authority to arrest without then addressing his unlawful entry into the home. So the district court did not abuse its discretion under the facts of this case when it refused to give that.
So I hadn't thought about that instruction in that tone until you just said that. So you've got both instruction as to the law for a bail bondsman's privilege. You're also saying there wasn't evidence in the record to justify that instruction as even a separate issue. Is that correct?
Yes, Your Honor. The lack of evidence to support that instruction is why the district court refused the instruction.
Regardless of parsing out the extent of the bail bondsman privilege.
Correct, Your Honor. Yes. In this case, what the district court really relied on is just the lack of evidence that Mr. Hubbard had any right to go in the home. So the court determined it would be misleading, confusing to give this instruction because once he did not have that authority to be engaging in the action he engaged in. The district court did not say, never in any case could there be an instruction like this. It was very much based on the facts or lack of facts to support that instruction.
But counsel, it goes to the relationship, or it goes to Mr. Hubbard's intent and why he was there to begin with, the statute. It doesn't say that, it doesn't mention third party or house, the third party's house. It talks about the relationship, the authority of a bail bondsman to do a certain thing. And doesn't that kind of define the trial in general?
Well, the statute did not give Mr. Hubbard a defense to his conduct. So it wasn't inappropriate to refuse the instruction. I mean, certainly the jury was well aware from this evidence, and the state never contested that, what bondsmen do. Mr. Hubbard testified about what bondsmen do. It was clear that, even there was a video played of the law enforcement interaction with Mr. Hubbard from the day before where they said, yeah, if you can bring him in, we'll arrest him. It was very clear that that's what bondsmen do. There was no doubt about that. But when looking at the elements of these offenses, his authority as a bondsman to arrest somebody and bring them in didn't provide him any defense to his conduct. Certainly when looking at the aggravated burglary and whether he entered or remained unlawfully, him being a bondsman did not give him any authority to enter that house. Opposing counsel has referenced the dissent in Stegall versus United States, but I think we need to look at, of course, the majority in Stegall versus United States, where the United States Supreme Court held that a police officer cannot enter a third party's home to arrest somebody. Nothing gave Mr. Hubbard the right to enter the third party's home.
On a search warrant, they distinguished between a search warrant and an arrest warrant.
Well, what they held in Stegall is that a law enforcement officer would need a search warrant. The arrest warrant did not give the authority to enter the home. A police officer would need a search warrant to be able to enter. There certainly was no search warrant in this case. So under the arrest warrant, a police officer didn't have the authority to enter the home. Mr. Hubbard also did not have the authority to enter the home. In Ruppnow, this court's Ruppnow case, this court stated that the statutes allowing a bondsman to arrest a principal do not elevate a surety's financial interests under a civil contract above a defendant's rights to liberty and due process, or provide a surety arrest authority far exceeding that of any law enforcement officer.
Well, does it matter that there was no arrest warrant in Ruppnow and there was in this case?
It does not matter. Certainly that is a distinguishing factor, but yet nevertheless, Ruppnow provides very useful guidance for this court. When Mr. Hubbard is trying to rely on the common law privilege that existed in the 1800s, Ruppnow is contrary to that. It demonstrates Montana is not relying on common law from the 1800s. One of the reasons that it is contrary to that is that the idea back in the 1800s under Taylor versus Traynter is that the principal is basically at all times in the custody of the bondsman. So the bondsman can anytime go find them and drag them back to court if the bondsman would like to do so. This court specifically held in Ruppnow that that is not what the statutes allow. So it demonstrates we are not operating under 1800s common law. Instead, we are operating under the statutes.
What's the state's...
That Taylor versus Tainter case, though, that was just dicta, because the case was about extradition and...
Absolutely, Your Honor. Yes. There are many. I think there are many reasons why we should not be relying on Taylor versus Traynter, and yes, that is one of them. Sorry, did you have a question?
That was my question.
Okay, great. Thank you. I also want to address some of the facts that have been alleged in this case where, one of them I'd like to address is the contract when it has been asserted that Mr. Sandoval contracted to allow Mr. Hubbard to use reasonable force against him. That the term reasonable force is contained in paragraph 3 of the extremely tiny and blurry font at the bottom of the contract. But the beginning of that paragraph, which is nearly impossible to read, refers to if Mr. Sandoval leaves the jurisdiction or the state. So that paragraph doesn't even apply here in any way. So I just want to clarify that Mr. Sandoval did not actually contract to have any reasonable force used against him. He did agree that Mr. Hubbard could apprehend and surrender him, but that was the extent of it. Also, in terms of the entry to the home, Mr. Hubbard did testify at trial that somebody opened the door and let them in. The jury heard that, but they also heard Mr. Hubbard's statement to law enforcement later that night, which was when he was asked if he knocked. He said, "I hate to admit it, but that's what, we went in without knocking because, first of all, he said, I knew Sandoval was in the house." And then the officer, in response, referred to the statement that Mr. Hubbard had already made that evening about how he wanted to get David Sandoval with the element of surprise. And when the officer referred to that, Mr. Hubbard said, "Yeah, if I knock, they're not opening that door." So his assertion at trial, the jury had good reason to not believe when he said, "They opened the door and let me in." Further, as this court was noting earlier, Mr. Harris was yelling at him to get out of his house. So certainly the jury had very good reason to doubt his statement about his lawful entry to the house. The jury also had great reason to doubt his statement at trial that Sandoval had punched him when he entered the room. That also was not what he told law enforcement the night of the offense. He told law enforcement at that time that he went in the room, told David Sandoval he was under arrest. Sandoval wouldn't get up from the bed, which would have made it hard to punch him. He wouldn't get up from the bed, so I tased him. That was the statements that Mr. Hubbard made that night, which the jury heard. So they certainly had reason to question some of that testimony. I think I failed to address the sufficiency of the evidence, so I just want to go back to that. The sufficiency of the evidence for the accountability to deliberate homicide charge. When viewing the sufficiency of the evidence should be viewed in the light most favorable to the state, and the conviction should be affirmed if a rational trier of fact could find all of the elements of the offense beyond a reasonable doubt when viewing the evidence in the light most favorable to the state. Here, the state had to prove, one, that Mr. Hubbard had the purpose to promote or facilitate the commission of deliberate homicide, and two, that he aided or abetted Nick in the planning or commission of deliberate homicide. The jury here could infer from the circumstantial evidence that Mr. Hubbard had the purpose to promote or facilitate the commission of deliberate homicide when he aided and abetted Nick in doing so. And the following evidence supports that. First of all, Mr. Hubbard brought Nick to this location to protect him, and he brought the weapons, which included the pistol and the taser. Mr. Hubbard started the physical altercation with Mr. Sandoval in the room when he tackled and tased him. Instead of leaving when Bill Harris ordered him out of the house, instead, he persisted and insisted that Mr. Sandoval was going to jail, even though the homeowner was ordering him out of the house. And then, significantly, in response to Bill Harris's threat to kick Mr. Hubbard threatened to shoot Bill Harris between the eyes. And what Nick Jaeger told law enforcement was that he made that threat, "I'll shoot you between the eyes," and then at that time he went to pull his pistol. Further, there's evidence that Mr. Hubbard enabled Mr. Jaeger to get the pistol, that he allowed him to get the pistol. Mr. Sandoval told law enforcement Jay gave Nick the gun. He repeated that multiple times. And the jury also heard evidence that Mr. Hubbard had gone into this house the day before, and people were curious about his weapons, and he made a statement about the pistol that if things got crazy, he was going to, quote, cap some motherfuckers. So the jury was aware of this evidence and could reasonably infer from this that Mr. Hubbard did have the mental state to commit the offense. If the court has no further questions, the state urges this court to affirm Mr. Hubbard's convictions for deliberate homicide by accountability and aggravated burglary. Thank you.
I have a question.
Okay.
On the Mitchell case from the federal district court. Yes. So what's your recommendation to the court on, do we say, yeah, there is a bail bondsman privilege by common law, but what Judge Christensen said is bail bondsmen don't have privileges that exceed law enforcement, and they don't have privileges that really exceed private citizens, or maybe are analogous to arrest power of private citizens. So number one, is it necessary for us to address that to resolve the case? And if so, what's your recommendation?
Well, first of all, it's not necessary to address that to resolve this case because the district court very specifically refused these instructions because he did not believe that there was authority to go into Bill Harris's house. So this case really dealt with that third party, third party privacy. So it's not necessary to determine in general what the rights would be. But I think, first of all, the Mitchell case came out before Ruppnow. And Ruppnow really demonstrates that this court does not interpret the bondsman privilege under the common law from the 1800s. Instead, we need to look at statutes and determine what the current statutes allow.
Well, in counsel, even if there were historically a common law bail bondsman privilege, wouldn't it be the case that to the extent the legislature has adopted statutes, those displace the common law?
Absolutely, Your Honor. Yes, that is exactly the reason, which I guess I meant to say that. That's exactly the reason why this is there, that we're not following the common law from the 1800s. The legislature has created statutes on this. That is what this court relied on in Ruppnow, and that is what should be viewed when determining the authority of a bail bondsman.
But I think the more detailed arrest statute was after this. This is a 2021 incident. I think 23 was the more detailed call the sheriff first statute. Am I right?
Yes, Your Honor, absolutely. I think
so we're
because
looking
of
at
this
the old-
incident, there were some details added to the statute. It's still very minimal.
But counsel, would you agree that the statute gives a bail bondsman more authority than a citizen's arrest?
Yes, yeah. It gives a bondsman the authority to arrest without requiring, there has to be a forfeiture of bail, a warrant, but then they have the authority to arrest without the requirements that would normally apply to a citizen arrest statute. In this case, Mr. Hubbard did request a citizen arrest statute, and it was given.
Is the big difference between a private party arrest and a bail bondsman arrest that you don't need the circumstances? I think it says something like the statute for a private party arrest is there needs to be circumstances requiring immediate arrest, whereas with a bondsman, if I see Joe on the street and I know Joe has a warrant for forfeiture, I can just arrest him right then.
Exactly, Your Honor. Yes, the citizen arrest statute requires the person to believe that the person is committing or has committed an offense, and in addition to that, it requires the immediate need for an arrest.
But even that is limited by the version of 46-9-510 that was in effect at the time, that the bail bondsman's authority to arrest someone has to take place before forfeiture of bail or within 90 days after forfeiture. I mean, there's still even a limitation on that.
Yes, that is how this court interpreted it in Ruppnow. Yes, Your Honor.
Any further questions for counsel? Okay, thank you.
Okay, thank you.
I'll use 5 minutes briefly. I'd like to start out with my rebuttal with Justice Bittigary's comment on page 3 of appellant's brief. That language specifically says Sandoval did not fill out the address portions and was unsure if he gave his last address to Hubbard. So this is Sandoval. The testimony at trial was that Sandoval was in the jail, Mr. Hubbard was in the jail, and he filled out, and Sandoval gave him the addresses and so forth that Hubbard put on the bail bondsman contract, or the bail contract. So that information came directly from Mr. Sandoval. Secondly, as to the notion that...
So I have a question. So if Mr. Sandoval just lists a laundry list of several addresses, everybody in his family, and places where he doesn't live, what's the obligation of a bail bondsman to do any due diligence to find that out? Or is your position he's just authorized to go in whatever laundry list of addresses that the client provides?
Well, that's certainly information that he has. He can go and check to see if, in fact, that's where, Mr. Sandoval lived. In this instance, Jay Hubbard saw David Sandoval at 815 South Main the day before, on December 18th. So he knew that Sandoval was there. He had seen him before Sandoval fled, went to a different place.
Being there is different than living there, right? So what due diligence did he do, or what evidence at trial showed that he investigated and found out of the several addresses he had where he was living?
Well, we presented the testimony of a lot of people, like Harold Mitchell, for example, Seth Babcock. All those folks, they testified to the nature of Mr. Sandoval's, remaining at the residence, and he slept there.
They didn't testify he lived there, right? He stayed there some. Mr. Harris let him stay sometimes. He was there some, but that's pretty different than them testifying he actually resided as his residence at that house.
Not necessarily. Again, if the court will look at the dissent, Justice Rehnquist's dissent in Staggled, Justice Rehnquist provides all kinds of instances where somebody might stay there or be there for a day or 2 days or 3 days or whatever. I think, again, when I began my argument, that's a fact question that the jury had to decide. And
But
so,
is Justice Rehnquist addressing a situation that's outside of Montana where there is no specific right to privacy enshrined in the Constitution?
no, he was addressing his notion that in that circumstance, the circumstance in Stiegel, where law enforcement went there to search. They didn't go there to arrest, they went there to search, and they tried to conduct a search. That's significant. Conducting a search is, you need a search warrant. To conduct an arrest, all you need is an arrest warrant.
Inside somebody's house? Are you
Yes.
saying law enforcement can go inside somebody's house with only an arrest warrant?
In Stiegel, it was based upon Peyton v. New York. You can go into the defendant's house to arrest
Without a search warrant?
without a search warrant. An arrest warrant satisfies the probable cause requirements for that. That's what it says. That's what the case says. And it's based on, again, Peyton v. New York.
I think it depends on the wording of the warrant. If the judge says you can enter to arrest, I've seen warrants that say that, and I've seen some that say it can only be served during daylight hours.
I don't think that's necessarily correct. I think that the warrant says to any officer, you are to arrest. And if the case law says you can go into the residence of the defendant, then you can go into the residence of the defendant. So,
Well, the probable cause on an arrest warrant is for the arrestee. It's not to enter the house.
well,
I mean, you can't enter people's houses without a search warrant.
the probable cause is, I know that there's reason to believe that an offense has been committed, and that guy needs to be taken into custody. So the Fourth Amendment speaks in terms of unreasonable searches and seizures. We're talking about a seizure of one specific thing. We're not talking about going around and rummaging through the cabinets and so forth to look for evidence of whatever. We're talking about the seizure of one person, and that's David Sandoval. I'm beyond my time, but I want to point this out. The notion that Mr. Hubbard did not tell the district judge that he believed that Sandoval lived there is incorrect. I would point the court to the order on the state's motion in limine, page 2. In that order, the district judge specifically says, the court is not persuaded that Hubbard believed Sandoval lived there. There was evidence before the district judge that Hubbard believed Sandoval lived there. And it wasn't up to the district judge to decide, it was up to the jury to decide. He should have given that instruction. I'll yield to co-counsel.
Thank you, Your Honors, again for inviting me here. I'm going to be quick like a bunny. First, I want to address the state's argument that the error in this case is not plain, and I would turn the court's attention to State versus Kern, which the state repeatedly cites in its own brief. Kern's a great case for Mr. Hubbard because it originated from the same district court and the same district court judge that Mr. Hubbard's case was tried in front of. Kern was an aggravated assault case, or an aggravated burglary case. And in that case, almost a year before Mr. Hubbard's case went to trial, this court said the conduct definition of purposely is incorrect. Now, the court didn't go the next step and say that it was plain error, but you at least have the district court who should have been aware that his prior instruction was incorrect. You have presumably the same prosecutors, or at least the same prosecutor's office, who was aware that the conduct-based definition of purposely was incorrect. And because it was decided a year earlier, it was incumbent on defense counsel to do the research and say, okay, what are the correct jury instructions? So the error from my perspective is plain. I would direct this court to, and I'll file a supplemental, but the case of United States versus Spann, it's found at 75 F. 3rd, 1383, and specifically 1389 and 90. In that case, the Ninth Circuit, essentially the case went up on a bungled jury instruction. That was the Ninth Circuit's word. The court did not find plain error. It went back on a 2255 on a habeas case. It came back to the Ninth Circuit, and at that stage, the Ninth Circuit said, counsel, there is no reason to bungle the jury instructions. And even if it wasn't plain error, it succeeds on the merits under the Strickland argument, and there was a reasonable probability. Justice McKinnon, and to some extent Judge Abbott, I do want to direct the court's attention to State versus Hovey. It's cited on page 31 of my brief, or our briefs. And in that case, this court said, it clarifies, different definitions of knowingly may be applied to different elements at once. This is not the Ring of Mordor. There is no one definition to bind them all. The courts, the district courts, can give different mental state definitions to different elements for the same offense. I want to talk about the rational juror. And there's case law back in the 30s, Dunn versus United States. This court has held in State versus Bailey, cautioned against speculating about what a jury may have done when reaching its verdict. The contrast to that, so we warn against speculation. Where the case turns is the presumption that the jury followed the instructions and that every time they read purposely, they read the wrong definition. And that's all I have.
Any further questions for counsel? All right, thank you.
Thank you, Your Honors.
All right, thank you, counsel. The case is submitted. Thank you all for attending today. Ready, clerk?